students, teachers, and the generally curious to the Constitution and American life with us, the Friends of Publius. The first thing I'd like to do is congratulate those schools who have qualified for the We the People National Finals. We hope we are of service to your endeavors. I know this is going to bug some of you, but it is Super Bowl week. And the Rams, my Rams, and I'm the only Ram fan in the group. Well, we won't talk about the others. I'm getting a little bit excited about this. But I will say, the Super Bowl is the best example of the wage and wealth gap in America. The average ticket at the Super Bowl is $10,000. All right. Yeah. The average family of four can enjoy a football game here in America. Oh, my gosh. I'm sure you guys have some thoughts about that. I do have a query, however, for Professor Moore. Tim here traveled from the great cheese state of Wisconsin this last weekend to the sunny nation state of California. And I'm just wondering, Tim, did you see any happy cows? Those Wisconsin immigrants who came to California. Did you see any happy cows while you were here?
No.
In California?
I didn't see anyone. I saw some cows, but I didn't see any happy cows. And like I've said, you guys produce way more cheese than we do, but we don't care. It's all crappy cheese.
We produce the cheese and the single slice things, right?
Yeah.
I think you said that to me once.
Yeah. So no happy cows. It was wonderful to have 72 and sunny. I kind of sat by the river there in Sacramento, and it was wonderful. It was wonderful. I got off the plane here, and it was 15 degrees, and so I'm back to reality.
Yeah. I know. That would be a shock to anybody's system. I got to mention, and to students and teachers alike, three of us have a bone to pick with you. Tim did an informal survey, and we found out that Dr. Williams is the overwhelming favorite friend of Publius, that he has quite the following. And we just, I've known him since he was 16. And, for those of you who love Professor Williams, just send me any question you have. And I've got a lot to share with you about, his foibles and things like that. There. Any comment, Professor Williams, there being the favorite friend of Publius?
I'm just honored to be with the three of you. That's all I can say.
You sound like a Major League Baseball. I'm just part of the team, coach.
Part of the team.
Yeah.
Happy to be here.
Just taking it day by day.
Just like any superstar. So, wow, talk about a change of direction. Last week, we attempted to get our hands around an extremely difficult, according to me personally, and broad question on the intelligence community, the NSA, and the Fourth Amendment. Well, thankfully, our authors of the national questions have provided us a much more narrow topic for tonight. Although Professor Moore disagrees vehemently about my description of the question, and that is Unit 2, Question 1 on the necessary and proper clause, which is, by the way, one of my, it's actually my favorite topic of discussion about the Constitution and Bill of Rights. And so what I'm hoping is that we can do a few things here. One is through our banter, I hope we can figure out whether or not Madison was truly schizophrenic, because if you look at his writings on the necessary and proper clause while he's in the Federalist and Anti-Federalist debate, and then while he is helping to form the Republican Party the Republican Party, there's a little discrepancy going on. But students and teachers, I think this debate cuts to the core of the fundamental question that I think all civics teachers try to guide, and all history teachers try to guide to, is this initial debate in the late 1780s, 1790s is really about what kind of America do we want? How do we envision the America? Whether it's and maybe it comes down to the Jefferson and Hamilton debate. Are we going to be an agrarian society with a strict view of the Constitution, very limited powers? of the national government, or are we going to be moving towards an industrial America in the view of Hamilton with some broad powers there, loose construction versus strict construction? And I will tell you, in working on my research this week, I found just some beautiful articles which really fit into the power of the courts and methods of interpretation, especially if you look at the debate over the Bank of the United States in 1791, as they try to construe the meaning of the word necessary, which we're going to try to do tonight. And hopefully we'll do an adequate job relative to our framers. So let's start our discussion as we have begun to do in the last few episodes, and that is to give guidance, if possible, to students and teachers about how they would approach this question. And, and I guess in a lot of the questions, there are what I call language minefields there. So I'm wondering, how would you suggest, gentlemen, that teachers and students approach this question? And do you see any language minefield in this question? So Professor Kavanaugh, I'd like to start with you tonight.
In terms of like minefields, is that what you're asking, David?
Either that or just generally, how would you approach it?
Well, I think obviously you're going to want to go back to the founding era, or the debates, honestly, not the founding era, but certainly to the debates over the Constitution. And I think it's imperative to look to see how the Anti-Federalists, like in the question, the quote from Old Whig, how they attack it, and then how do the Federalists defend it. And I think it's interesting then to see how that debate plays out today. And I think that's true with about any kind of Federalist, Anti-Federalist question, is that, these were the arguments, whose argument was better, and who was right in the long term. So I don't know that there's any, language minefields, though.
Well, and what I meant by that is last week with the Intel community, and there were some minefields there, because
right.
there were 100 ways you could go. I don't think there's 100 ways you can go on this. I think there's a great debate to be had, a great discussion to be had on this question. I just don't think the kids have to work a lot to try to figure out which direction to go. It seems relatively straightforward to me. But Professor Moore, in our previous interaction, you seem to disagree with me. You think this is a very broad question.
No, I think the debate is intense and continues. I think you're right in your assessment of comparing it to the national security apparatus. So in many ways, it's kind of a modern debate. So I would say that this debate about this particular clause, and I like your opening statement, because I think the minefield, I would agree with Chris that there aren't any really word problems, I don't think, in this question. But I do think the minefield is to start your thinking with the ratification debates. I think that's a minefield. If and maybe this is an advice to students approach here, but there's a lot of concern about limited government and unlimited government long before we get to the ratification debates, and that goes back to colonial precedent. So I would recommend students, the depth of this is historical backwards in some ways. So I would recommend they do their work on the colonial history piece about, and to your point, interpreting whether it's a strict Constitution or whether it's a loose interpretation. So that's how I would say if there's any minefields to be had in this.
Professor Williams, any thoughts?
Yeah, I really liked what both Chris and Tim had to say, and I agree. I think I would recommend that students think about how this clause is situated in the larger Constitution. I think there's going to be a tendency to want to get down into let's talk about how necessary has been interpreted. And I think, as we're going to talk about today, this notion of proper gets us to this sense of, well, we are trying to create a government that is limited. And we have to think about how this clause sort of is situated in the broader Constitution. And while Tim says maybe going backwards, I think also maybe going forwards a little bit and thinking about, the 10th Amendment as well, as you're thinking about how this clause is shaped by the Bill of Rights and by the 10th Amendment specifically. But I do think the students working on this have a much better direction than the students with the Intel one, which they could go in any different direction.
So as we normally do, and I apologize for this if I get caught into a sequence that is the same over and over again, but Professor Moore is our expert on the colonial founding period, and since we like to cover the spectrum of things, it's always, I think, wise to start with the history here. And hopefully I can get you to focus here, Professor Moore, and that is purpose. All right, because anyway, what's the purpose of Article 1, Section 8, Clause 18, the necessary and proper clause? Why did they put it there? Not necessarily Clause 18, but why did they insert a necessary and proper clause to begin with?
Well, I think, Chris can help me out on this because I know he's recently reread a lot of things about the convention itself. But there's an argument to be made that the necessary and proper clause was a product of compromises at the convention, because if you remember Madison's plan, the Randolph Plan written by Madison, had this statement, I think it was Article 6 of the Virginia Plan, that said, these were rough statements that were going to be discussed that summer. And statement number 6, it said there ought to be a national legislature that had the ability to legislate where the states are incompetent. And then like a sentence later, it said what's been called the national veto. It had the ability to veto all state laws if it violated the national constitution. So those are pretty stark statements. And as the summer unfolds, Madison loses that proposal of the national veto. Now, some would say, well, the necessary and proper clause is kind of, you combine that with the supremacy clause and you bake at 350 for 45 minutes and you get the national veto that Madison wanted. Not the same verbiage, but the same kind of idea. So there is an argument to be made that it's there because they're bargaining at Philadelphia. Now, I would the other view of this is there's historical precedence for it to not be there, and that's why the Anti-Federalists go crazy because they're arguing all this British history.
Well, is it accurate to say, Tim, that at Philadelphia there was no debate over this clause? To my understanding, and based on what I've read, they didn't debate the language of this clause at Philadelphia. It was something that came up in ratification.
Right, because they're all national. I mean, think of here's another minefield for students. Now that you ask it that way, David, a lot of people use this phrase, the Anti-Federalists at the convention. No. They're all nationalists at the convention of varying degrees. So in some ways, it makes sense that a necessary and proper clause occurs because they're all nationalists. And I love Fed 44, I think it is, where Madison, I read it through this afternoon and I had to chuckle. It's kind of like a Goldilocks essay. We could have done this, we could have done that, we could have taken the articles way, we could have said do whatever they want, but we hit it, the convention hit it just right. It kind of was a chuckle to me that he concludes that this is absolutely necessary because it's necessary. We can't think of everything is kind of what he concludes in Fed 44.
You just blew my mind, but you said they're all nationalist.
Yeah, I would make that argument. Yes. Now
Chris?
they get nervous as the summer goes on. Like as you well know, there's a couple delegates from New York that leave because they don't like the way things are going. So yeah, and Luther Martin is a nationalist, but as it unfolds, there begin to be some misgivings about that.
Chris, do you agree with that? That they're all nationalists?
Well, I think, yeah, because I do, but I think that then obviously we think of the three guys that stayed and didn't sign, right? Randolph, Mason, and Gary, for various things. But if you look at their participation throughout the summer in Philly, they're working on this document as well. And so they all get to the point where there's certain reasons why they won't endorse it or sign it. But I don't think that's, I think, and I'm going to defer to Tim on this anyway. But I do think that's legit. But I think if you go back and look, the idea of necessary and proper, that's a term that was around, right? That was a term that had been there. And I was researching for this. I actually did some research, and Tim alluded to Resolution 6 of the Virginia Plan, or the Randolph Plan. And the second part of that sentence, because this really helps shape the concept of federalism. This really is a federalism question if the students and teachers think about this, because I quoted the first part of that, right? But interpreting concept, understanding concept. I'm trying to think. I just had called it up here. To legislate in all cases in which the separate states are incompetent, or in which the harmony of the United States may be interrupted by the exercise of individual legislation. So the idea that states doing their own thing, that's Madison in the Virginia Plan, which Tim mentioned the national veto, which Madison actually tried to get into the Bill of Rights as well and didn't get it in there. But the origin of this clause is going back to James Wilson. James Wilson was on the Committee on Detail and a lawyer, and going back to, and I think if he's going to get a chance to expand national power, he's going to take it. Because if you, for students and teachers, Wilson writes the National Bank essay in 1785, 2 years before the convention, and talking about the inherent power in a government. So if you're going to have a national government that is going to do something with money, whether it be taxes, borrow money, or those, it's an inherent power that you should be able to have a bank. It's an implied power. And
well,
so Wilson,
no, go ahead, Chris.
Bill Wilson on the Committee on Detail, who's writing this clause, is writing in a way that it can be construed to expand the national government's power.
Chris, Mike, Tim, I need just a real quick affirmation. I came across that the individual actually presented this in Philadelphia was a delegate by the name of Gunning Bedford. Is that accurate?
Yeah. You could be right. I got a book here I could thumb through and find that real quick.
And it said to legislate in all cases for the general interest of the union, and also in those to which the states are separately incompetent.
Yep.
All right. Or in which the harmony of the United States may be interrupted by the exercise of individual legislation. That's the first language, and obviously it's rejected there, and that's how we come up.
But listen to that federalism. I mean, Chris's point is well taken. There's a tremendous federalism in that statement.
Right, it's all about that. But here's the question to you, Chris, is that in Federalist 33 and Federalist 44, it seems that Hamilton and Madison are saying this is but just a truism. This language is just reaffirming what we all know, that if you're going to give legislative power to Congress, of course they have to have necessary and proper powers to implement.
Right.
So what are the Anti-Federalists? What are they all upset about?
Let me first jump into 44. Sorry, Timmy, I saw you. I just love this sentence in Fed 44. So I'm going to read the sentence, and for students and teachers, this is in Federalist 44. This is Madison. No axiom is more clearly established in law or in reason than that whenever the end is required, the means are authorized. Wherever a general power to do a thing is given, every particular power necessary for doing it is included. So there's a minefield That might be a minefield. So yeah, and David is right in 33 and 44. I think they're basically saying, of course this has to happen, because if you're going to have a government and they're going to carry these things into fruition, to these laws, different laws, and these enumerated powers that they have to be able to do these things. So therefore, it is necessary and proper for the government to have these powers. So and it's also, it's 33 and 44 are also, don't worry, trust us, we got this, we're okay, this is not what you think. And of course the anti-feds, and I know Tim can address this, I mean, there's a word the anti-feds want to use, and that's expressly. That is such a key word here, because it's not in there. And so we actually get that too in the 10th Amendment.
Yeah.
Well, not expressly.
I know, but that's a debate about that.
Right. Oh, right.
Well, before we go to
eight of the 13 recommendatory sets of recommendatory amendments after Massachusetts want that, and they all say they want that word expressly delegated to limit the national government. But to your point, David, I got to push back a little bit. With the Anti-Federalists, what are they really worried about? They're arguing history. Remember, British colonial constitutionalism is a parliament sovereign. So what that means is when a parliament, way back when a king revokes charters, or a sovereign parliament wants to regulate trade throughout the realm, when a parliament revokes, changes their status from realm to dominion, when the Stamp Act occurs, the Declaratory Act, the Intolerable, and one of the intolerable acts, the Massachusetts Government Act, actually prorogues the Massachusetts legislature. So what the Anti-Federalists are fearful of is a legislature who they've seen in the British context do whatever the hell it wants to, or excuse me, whatever the heck it wants to. So they're real. Did that put us to PG-13?
No, it may be.
Actually, I think we get one F-bomb. If the second F-bomb.
So what the anti-fed, to your point, is I have to defend the honor of the anti-federalists here, is they have seen a sovereign parliament do all kinds of stuff. And I think it's Brutus who expressly says this necessary and proper clause is just like the Declaratory Act. So don't blow smoke of our skirts. This is a declaratory act. And that's Adam said that's when the revolution began in 66 with the Declaratory Act. So it's history they're arguing.
I want to turn to Mike in a minute, but I just need a fact check by you and Chris. Didn't the articles deal with the language expressly delegated?
Yep.
So in Philadelphia, they chose to ignore that.
Yes. And that's, I think, Madison says that in 44 when he lays out we could have used the articles language, so he acknowledges that that's in the articles and we didn't do that.
All right, pop star Mike Williams has been trying to get in here. So
I have a question, a textual question for the three of you, because in my research, the clause says necessary and proper for carrying into execution the foregoing powers. So they didn't get the expressive language, but they got the foregoing powers. But then it's a comma, and it's all other powers vested in this Constitution and the government of the United States, or in any department or officer thereof. And I'm wondering if it's after the foregoing powers is what raises the cockles of the Anti-Federalists, because what are these all powers vested? That to me seems to be where you could drive the truck. Like, just, you don't care about enumerated powers anymore.
You're exactly right, because some Anti-Federalists went, let's look at the courts. How far will they be able to go? And that obviously shows up in all the visceral response to McCulloch. So the Anti-Federalists do go to these other branches in how they would be given carte blanche under this necessary and proper. So you're exactly right. It's not just limited to Congress.
Right.
And for the students who are preparing for nationals and teachers, I think if you're thinking about trying to set yourself apart a little bit, think about the necessary and proper clause as three different or distinct clauses. It's the one that Mike just alluded to that we know, foregoing powers, right? And this way, well, we can't do it unless it's listed here. See McCullough, see Sebelius, the healthcare case, right? But there's also all other powers vested in the Constitution of the government of the United States, and in the third one, any department or officer of the United States. So I think if students and teachers approach this question and divide it in that regard, I think that might separate you from some of your competition.
Well, and doesn't Marshall and McCullough, he doesn't refer to enumerated powers. Isn't that part of the decision? He refers to it as Congress has more of the implied power. Am I right with that? As he's connecting it to commerce?
Well, but he bakes a cake too. I mean, he goes to taxation, he goes to credit, regulation of commerce. So he goes to other powers as well.
This is one of those classroom experiences where I've totally lost control. You guys have now covered pretty much every question I had written down tonight. So we could end here, but we won't. So I do have to ask a quick question. Is this the source of implied powers? Is this clause one of the major sources of implied powers?
Oh, major. Well.
Oh, now you're going to get cheeky.
I'll go first. I think it is, especially after McCullough.
Yes, I would agree to that. Yeah.
And I want to reiterate something Tim has said earlier too for the students. When you're thinking of the Anti-Federalist complaints, almost always, not always, but many times, it is linked with the supremacy clause. So make sure you're in your research and what you're thinking about. And you should find this when you're encountering some of the like Old Whig 2, I think, which is the quote is from in the question. They also include the supremacy clause. So the supremacy clause in Article 6, coupled with this involved and detailed necessary and proper clause, absolutely, David, goes to the idea of implied powers.
And a lot of taxation linkage too in many other anti-federalists.
Mike, you're paying the price of being the most popular one. These two guys just won't let you speak. Go ahead.
No, shut up. No, I think that with the implied powers, I think this is where it's important to think about the role of the word proper here, right? I mean, I think there's a way to sort of do what Marshall does in McCullough. He expands necessary, right? But the proper is just because you have the right to use the power, right, doesn't mean you get to use it if it's not proprietary, right? If it's not in the spirit of what we are doing in the larger Constitution, which brings me back to what we were talking about earlier. You can't understand the way these things are getting argued unless you're trying to also fit it in with the larger debates around federalism. I think ultimately the 10th Amendment, all those are going to be important ways to limit it. So in the quote from the question, it says, what are the limits of their authority? I fear none at all. Well, I think that's an overstatement, right? I think by thinking about the nature of the Constitution itself and federalism, I think that there are going to be some limits. It's not going to be the limits the Anti-Federalists want, and it may be not the limits that we want, but I think there are some limits that are inherent there as well.
So students, I'm going to ask questions for the remainder of our time together, of which they're not going to answer whatsoever because they probably already answered them, but let's have fun with it anyway. So Professor Williams, as the one person here who's been trained in the, in legal language, being, someone who went through law school, explain to us what necessary means. How a piece of legislation can be accepted as necessary. How's that break down in the debates over this clause?
Well, let's think about some examples, right? Congress may say, look, we have the power, we have the commerce power. We can regulate interstate commerce. And one of the things we want to do is we want to control the wheat market. So since we control interstate commerce and there's this wheat that could get into interstate commerce, it's necessary for us to tell wheat farmers, stop growing wheat, right? And you may, as a justice, say, yeah, if you, Congress, want to do that, we can see your argument. If you want a huge, a huge interpretation, right? It's necessary for this. But then, is it proper? Like, is it something that we should?
Oh, wait, don't go on to proper yet. How is necessary separated from the word convenient? I mean, conveniency to carry out.
Well, that's exactly what.
Yeah.
That's exactly what comes up in the bank debate, because both Jefferson and Madison say it might be convenient, but that's not enough. So they want to parse that word out to exclude convenient.
But this is where, I mean, this is where Marshall immediately, right? I think isn't the first decision Finch? Is it Finch? I may be messing up that.
There's Fish. It's an 1805 case.
Right. I mean, he immediately sets the bar so kind of low to meet the necessary. It becomes kind of like, well, it doesn't have to be. Congress can look at a lot of different ways to do this, and as long as it's rational, as long as it's reasonable, he's gonna allow it. And what people who haven't liked this kind of sweeping nature of the clause since that time, since the early 1800s, have been fighting back, have been saying there has to be some way to limit it. So
to Chris and Tim, and Mike was referencing an 1805 case, U.S. versus Fisher, which, and again, this has been such a fun experience for me, you know, to prepare for this, because I found out a number of things that I didn't even while I taught it. In U.S. versus Fisher in 1805, Marshall says Congress must possess the choice and must be empowered to use any means which are in fact conducive to the exercise of a power granted by the Constitution. Man, that's a really broad understanding of the word necessary. And so how do you guys respond to that? How do you deal with that?
Well, he's saying, you know, he's a nationalist. I mean, there are many books about Marshall that don't even deal with anything much to do with his legal theories. It's all about a national vision. I mean, one of your opening statements was whether this is going to be a Hamiltonian country or not. And Hamilton's an admirer of the British economic and maybe even mercantile system. Could it work here in the United States? So a national regulatory or national commerce entity is absolutely necessary in a Hamiltonian and Marshall view of the economy. So it's a nationalism.
Right. And just going back a little bit more with Marshall for the students and teachers, if you read his very, very brief autobiography, it's more of a pamphlet, it seems like, you know, he was with Washington at Valley Forge. And so he writes about the fact that there were men from all over the country, right? From colonies / states from all over the country. And so as a young guy that's pushing through in this time of war, he's kind of developing that concept of nationalism. He sees that, he writes about that in his autobiography, like seeing these people from all around the different colonies / states. Therefore, it's a new nation we're building, not an aggregate of states. So I think that helps to drive some of his vision, and to just echo what Tim was saying about nationalism. So David, could you go back to your original question then? I'm sorry.
I don't know if I can. I got so enamored with your current debate. One, I still don't.
Oh, what's necessary?
Well, the core question is, how do we define necessary? And it seems to me that there's this gap between absolutely necessary versus,
right.
You know what? And this seems to be affirmed in Federalist 33 and 44 is, listen, you know, the necessary part of this is just a truism. Congress is going to have to be able to carry out their legislation, and therefore conveniency. It's convenient to do so. So those seem to be the parameters. Absolutely necessary versus it's convenient to do so, and there's a gap in between. Marshall in 1805 seems to take that very, very broad. Now, does he retract that to some degree in McCulloch? And that's to you and Tim. I mean,
No,
to what
no.
degree in McCullough does he retract that very broad decision in 1805 and give it some more narrow parameters?
Well, it's more narrow in McCullough, simply as Tim already alluded to. He ties it to other provisions within Article 1, Section 8. Right, he ties up the bow with Article 1, Section 8, Paragraph 18, necessary and proper, but he links it to those foregoing powers. The first, if you will, the first necessary and proper clause, just dealing with the foregoing powers. Because if you read the opinion, he is talking about the idea of banking. He is talking about the idea of commerce. So it's a more narrow ruling. And I'm not familiar with the 1805 case that you guys cited, so I can't speak to that. But I think if that's broad, I see a narrowing version within McCullough because he's linking it to these other powers.
Yeah,
Well,
but
Jefferson didn't think it was narrow. I think the great letter to I think Spencer Rowan,
yes,
where he says if we let Marshall get by with this, the Constitution is a thing of wax, and and again he's got himself worked up about his cousin being able to interpret the Constitution however he wants. So Jefferson didn't think it was a narrowing, but I'll have to defer. I'm not familiar with that case in 05 either. So,
well, and for students, when he says a thing of wax, what he means is it's easily malleable, it's easily moldable or shapeable, right? So the idea is that you're gonna, and this goes back to David, to your point originally, or not earlier, but the idea that the necessary and proper with the supremacy clause is going to give the courts a great deal, because you're asking us to define necessary. I think all you have to do is make sure you get 5 people to agree with you, 5 people wearing black robes, and they get to decide what's necessary. And that's what scared the bejesus out of Jefferson.
But Marshall also argued, right? He said, look, the drafters of the Constitution knew how to write different language. And he points out that Article 1, Section 10, which prohibits states from, quote,
right,
from laying imposts or duties on imports or exports, except which may be absolutely necessary,
right,
from their, right? So he kind of argues they knew how to put this language in if they wanted to. So and again, to get back to Chris, a lot of these founders, they're lawyers, they're corporate lawyers. I read a lot of stuff this week as well, talking about how, if you see the Constitution as a corporate charter, right, you're gonna give a lot of flexibility there. That's just the way that the legal minds at the time would have interpreted it.
Well, and that's Wilson. That's our boy Wilson. He was a corporate lawyer, so he's committee of detail. He's writing this clause, and he was a corporate lawyer dealing with land companies in what we call the Old Northwest Territories. Yeah. So he understands this. So yeah, there's some corporateness, if that's a word. Related.
Yes, it is a word, but I want to go back to what Mike said about they knew what they were doing, because he references Article 1, Section 10, but in Article 2, Section 3, they say the president to recommend to Congress such measures as he shall judge necessary and expedient. They don't use absolutely necessary as they did, all right, in Article
David,
1. Or
David, because he's part of the national government.
Who?
The president. And these states in Article 1, Section 10.
Well, Congress is part of the. Wait. Okay, did I just have a brain fart dumb movement?
I think
Congress
so.
is part of the national government. So in one section, they're saying there's a strict interpretation of necessary, but in another section, and I think this reaffirms Mike, they knew what they were doing. When to have more restrictive language, when to have broader language there. And Article 1, Section 8, Clause 18 does not have broad language, Chris. It's just necessary. It doesn't say absolutely necessary.
Okay, so
I think your point's well to focus on that word expedient.
Yes.
I mean, I kind of would say necessary and proper is it's necessary and it's legal. Whereas with the statement about the president, he can show up and make recommendations that are necessary and expedient. Well, it's not up to him, and this flies in the face of Jefferson's view of each branch gets to interpret for their own powers. But I would say that necessary and expedient isn't as serious as necessary and proper, because proper for me means legal.
And I'm going to go back and defend myself here. And again, I'm not trained in the law as one of our pop star member is, but he's not even going to look up at the camera. Article 1, Section 8, Paragraph 18 is dealing with Congress, part of the national government. Article 2, dealing with the executive. Article 1, Section 10 is putting limits on the states. So in essence, it's confining the states even to a greater degree.
Right,
that was my point.
Yep.
Absolutely necessary for the states. You only get to do it if it's absolutely necessary, you states.
Well, here's a question that I'm going to insert.
You got
it's been referenced before, and it's and in hearing the conversation here, as usual, I'm feeling pretty dumb, and like I misguided students for 16 years. But you said it's to make all laws which shall be necessary and proper for carrying out into execution the foregoing powers and all other powers vested by this Constitution and the government of the United States and any department or officer therefore. So this clause not only applies to Congress, it applies to other officers and other branches. Is that an adequate understanding on my behalf, or am I just really out to lunch?
Well, you're a genius, and that's exactly why the Anti-Federalists are scared to death.
Okay, so that's true. In 1789,
which part? You're a genius, or they're scared to death?
No. I'm not. I'm the farthest removed from genius in this group, but that this does apply to other branches. That is an acceptable understanding of this clause.
Yes,
right. I'd also say that in Article 3, there's a necessary and proper. There's a glimmer of necessary and proper in Article 3 when courts have equity power.
So I'm just wondering, Madison loses his Virginia plan, and I'm not going to say Madison.
I thought you were going to say something else for a second.
Yeah. Okay. Yeah. Okay. I'm not going there. But is this a backdoor way to create some semblance of plenary power amongst the national government?
He gets his national veto. That's what I think some people would see, that he does get a national veto. To your point, David.
And that's what I think. Yeah, absolutely. Because this is what you see. You just have to look at the Anti-Federalist complaints, because that's what they're concerned about, is the stuff that we're doing within our state. They can come in and strike down anything that we do within our state under this umbrella of necessary and proper and supremacy. So in essence, that's one of the reasons that they're terrified of this.
Mike?
No, that's my understanding as well. And that's why looking back, I understand what the Anti-Federalists are fearful about. Now, I think that we have seen the system mature in a way to maybe, I don't think the Anti-Federalists were going to be happy with where we're at today, but it hasn't gone to the extent of what we saw maybe Parliament doing with the declaratory acts. Maybe.
So, and some of the Anti-Federalist complaints would refer to this as the new Declaratory Act.
Yep. I think it's actually old Whig does that in this essay.
So I'm going to make this a two-part question here, Chris. First of all, between McCulloch, all right, and the New Deal, all right, is there such an expansive view of federal power that it's disturbing? Because we know, and I came across this in numerous sources, the New Deal changes the equation. And in fact, it's not just the necessary and proper clause plus commerce, which we know, especially from McCulloch on, that's being used, but it's the necessary and proper clause on its own, all right, that allows for the expansion of power there. So this language, which was rejected at Philadelphia, this language of very broad, seems to have become, from the New Deal until recently, the language of the necessary and proper clause. Do you agree with that? That from the New Deal on, that expansive view of that clause has been generally accepted?
No.
Oh.
Well, no, I don't think it's universally accepted. I think there's always going to be pushback. I think there are going to be, the small government people that will push back. And I think you see that in some cases, that will lead to the court packing scheme, right? When the Supreme Court starts to strike down some legislation as being too far, too big of a reach, you start to see that. And of course, then, FDR starts thinking about packing the court, and then the courts, they check to see which way the wind's blowing, and they start to maybe make some changes in some of their decisions regarding New Deal legislation. I don't think so. And I'm going to go back, and I'm not trying to be flippant about this. Maybe I am, but I don't think I am in terms of what's necessary. Bottom line, it's going to come down to 5 votes. I mean, because we may disagree on a piece of legislation, whether it's really necessary, whether it be for carrying into foregoing powers or the different provisions within different, departments within the government. But then when it gets challenged, it's up to whether the courts can find that power within the 4 corners of the Constitution and would agree with it. So I don't think it's a rubber stamp, David. Is I think that's what you're implying.
But historically, all right, you're a historian, a constitutional historian, at least from 1937 to 1995. That seemed to be the general prescription and understanding of the necessary and proper clause. Yeah, I mean, there was not a single law by Congress struck down by the courts in those 60 years. Right. And I don't think you see it until you get to Lopez. Lopez, the gun-free school zone case, right? And that's where you actually start to see. That's where you see, was it Rehnquist, Chief Justice Rehnquist's opinion to say, your reasoning is really a reach here. So I don't know, but maybe, I don't know. I'm just thinking here out loud. Is that the aftermath of the Civil War? That the idea is that, say states, you can't really do what you want to do in the national government. No, because in the
states do all kinds of things.
Well, true. I mean, okay, Jim Crow, yeah.
They're striking down a number of things in the Lochner era, at least by, both by Congress and by states there. And that's why I say I think the turning point is the New Deal in what is called a constitutional revolution there. And like I said, I'm just wondering, did that original language before this?
So the original language before the necessary. I mean,
well, I'd like to come back. I'm way out of my league on this because this is 20th century law. But I think I don't know that the Congress needs to actually use the necessary and proper clause much, because in many of their preambles before they act, like if they're passing a law, in their introductory statements, they often just broadly interpret a stated power in Article 1, Section 8. And they don't even bother with necessary and proper clause. Now, like I said, I'm way out on a limb on that, but if I'm right on that, there's no need for the necessary and proper if we can interpret our power as broadly under a stated text, piece of text.
Okay, well, 2 things there. I think you would have to, if you're just linking it to the Commerce Clause, right? You would then have to have, if the necessary and proper clause isn't there, you'd have to have an implied understanding for Congress to do what's necessary and proper for that, okay? But I think you're right. I think I wanted to mention this for the students. There's 2 different types of debates you're going to find in the case law. One is where you're arguing over, okay, is this really commerce that Congress that fits, right? Is prohibiting where people can have guns, is that really about commerce, right? Versus these other cases, I'd have the students look at a 2010 case called Comstock that had to do with Congress passed a law saying that they could keep federal prisoners in prison longer than their sentence, right?
Right.
I won't go into the details here, but if you read Justice Thomas's dissent, right, he basically says, look, they have not attached, nowhere has it been argued in the decision by Breyer wrote the majority, of what enumerated power this is going to. Breyer takes us through these inferences. Some scholars have called it the chain link kind of argument, like follow me here, follow me here, follow me here, and blah, all of a sudden Congress can do it. In Congress, in Thomas's dissent in 2010 in this case, actually becomes what the majority uses to say that it was under necessary and proper that you could use it for the individual mandate in the Healthcare Act. So I think students, it's good, Tim, you mentioned that, to look at those two different ways this can happen, attaching to something, a foregoing power, versus just expanding, using necessary and proper as a way to get more power.
Which actually goes, listening to you explain Breyer's opinion in Comstock, and I remember that case now because I remember taking a look at that. And for students, it's really about people that have served their sentence, but authorities, whether it be prison authorities, believe the person is still a threat to society. Right. Has not been any type of, there'd be a harm to society to release this person back into society. Reminds me of Madison's axiom in Fed 44, right? Yep. When there's a need, we're going to find a way.
Yeah. Well, it's interesting in this Comstock decision, as I was learning about it as well, reminding myself, Breyer uses a hypothetical that has nothing to do with the case, right?
Shocking.
He says, well, of course, if there was an epidemic in the country and we needed to keep prisoners in prison and inoculate them, we wouldn't say that Congress didn't have the power to mandate that, which is exactly kind of one of the things that we're obviously talking about today, right?
Oh, that's a gem for students and teachers watching. That is a nugget, man.
Yeah.
That's awesome.
Welcome back.
You're muted, David.
Hello. It's nice to see you, gentlemen, again. So I wanted to ask, we've dealt with necessary and we've danced around proper. And Professor Williams, I wanted to ask this question about proper. And I've always wondered, if something's necessary, how can it be improper?
Yeah, no, we've talked about this a little bit. So yeah, Chris and Tim, please chime in on this. It's something that the justices haven't spent a lot of time articulating until recently. So again, we're talking about Comstock. This is basically what Thomas is saying in the dissent there. It's in the Sebelius case. It's the driving point. And I think the distinction students should think about is this. If you decide that Congress has an enumerated power and they want to create something that is necessary to advance that power, the proper section is kind of like, it comes from like this idea of propriety, right? Is it within the scheme of our constitutional system, is this something that we should be allowed? And what the majority said in Sebelius is they said, well, we have to look at the 10th Amendment. And you can't say something is necessary in a way that then upends the sovereign rights of states to have, we have a dual sovereignty system, and you have to allow states some powers to still do things on their end. So just because we assume that maybe it's, sure, we buy you, Congress, it's necessary for you to do this, but it's not going to be proper, because if we allow this, then we are really having a parliamentary sovereign system with no checks for what the states can do at all. That's the way I understand it. But
I would like to go back and my very first statement for tonight's program, I'm going to say there are a lot of minefields now because we're talking about what's necessary, what's proper. And I think maybe for the students, is it necessary? Is it needed? Should we have this, right? Proper, does it mean, is there power to do it? Within the four corners of the document, go old Dean Smith on you, within the four corners of the document, is there a power within there for this to be carried out? So it may be needed, but there is not a power there. And I think that is the idea of Thomas's dissent in Comstock. Is that right, Mike?
Yeah. And I have maybe a better example. Sorry, Tim. Since you look at the Prince case, it had to do with the Brady Bill. And as part of that, part of the law said, okay, local sheriffs, you have to assist us of getting people to register their handguns on this federal registry. And what the court said in Prince is they said, look, we agree this is setting up the background check, or was it the background? It was background check. Setting that up, that is a necessary way to enact this, what you're saying is a commerce power, right? But it's not proper. You can't tell state officials what to do, right? We don't view that as a proper use of federal power, so you don't get to do that. Now, as it turned out, most local sheriffs cooperated and did it, but the point is that the federal government, the Congress, couldn't force them to take part in this federal program.
Only because, I'm going to go back and defend a previous point, only because they didn't get the 5 votes on the court.
Yes.
Anything, Professor Moore, you'd like to add on?
No, I went out on a limb on that 20th century statement here about 5 minutes ago, so I am not willing to go out there again.
Can you tell us about Wickard v. Filburn?
Yeah, no.
Oh yeah, there we go. There's the guy who wanted to put his weed into market and screwed up the national economy. Come on, really?
Okay, we can have fun with that, but it does seem that, at least from what I read, New Deal 37 to 95, we have a judicial constitutional revolution in the interpretation of the necessary and proper clause, much of which is attached to the Commerce Clause, but some of which is not.
Well, David, and I understand that now, and I think I would agree with that. But my question would be, is it simply because of the dictates of the time when you have a depression, 25%?
You know what you're doing here, Kavanaugh, and I love it.
No, it's a question. It really is a question.
It seems to me that you're saying that the written word doesn't mean anything. It's about the 5 people who are on the court. That's what you seem to be saying, which I'm okay with, but I don't know if teachers.
Well, as historians, we understand that context is a big thing here, right? And so I'm just trying to understand. I'm agreeing with what you're saying in terms of the court and the expansion of this clause during this time frame, but I'm wondering if it's simply because of the dictates of the time. During the Depression, you have 25% unemployment. You've got massive issues with the Dust Bowl. You've got problems everywhere.
It continues on, Chris, beyond the New Deal.
Right.
All right. The court's interpretation of this clause, usually attached to the commerce, but not always.
Yeah, but David, how often,
the Great Depression.
Was it Socrates said, once a mind is stretched to beyond it, rarely does it return? It's the same thing with power, right? Once power is assumed by an entity, rarely does that entity get that power back.
I surrender. When you start going to Socrates, I surrender. Okay, you win, kind of stuff. But I'm
agreeing with you. I'm just trying to figure out why that is. Not why I'm agreeing with you.
I mean, for Marshall, he sees a national crisis if we don't have a national economy.
Yes.
For FDR, the progressives, they pass legislation because if we don't pass national legislation, we have a mess with the beginnings of, we're all scared to death of communism in the early 20th century. With the New Deal, there's a national problem. So I think I could meet Chris halfway on that, as long as you get 5 votes. But I do think there's a national overlay to this. These moments where things expand, there's and 5 people on the court are enough to perceive a national issue. And Marshall kind of dabbles around this in a really contorted way. In the McCullough decision, he says that the Constitution's a national document for national issues. The people have created this national thing. So, I mean, he puts his nationalism right out there in the early parts of McCullough. So I would say there's a nationalism component to all these expansions.
So, Professor Williams, considering the current court, are we going to be living through a counter revolution of the what we'll call the New Deal period that lasted all the way, and at least till Lopez, and I think it surpassed Lopez. Lopez was the one out in some ways until Sebelius and Prince. But do you think we're in going to be in a period of counter-revolution to the reading of the necessary and proper clause?
Yeah, I do. I mean, to get to Tim's point and to Chris's point, you know, the Constitution and the interpretation of the Constitution, in some ways, it has to react to the times that we're in, right? We're not like France, where we've had 5 different constitutions that we write as situations change. And I think, you know, the guardrail is that those changes need to happen within certain limits. And there is a certain cycle. I think for those anti-federalists in our society right now, they should be pleased with the Lopez decisions and the Sebelius decisions, and the fact that there is sort of maybe this pushback. I think that is a way that we can be living in a democracy with a constitution that is malleable with the times, right? I would add that it's interesting to watch Justice Roberts navigate this, right? He seems very attuned to the fact that to disrupt some of the precedents of the court and to some of the ways they've been interpreting, not just the necessary and proper, I'm speaking more broadly, that the court needs to be careful, that its very legitimacy rests on the fact that it's seen as not as another political branch. And so I think we are going to see that counter-revolution. I think it's going to be interesting to watch how Roberts tries to navigate that on the court. And even if he can do anything, he may just not have the numbers to get to Chris's point now, right? But yeah.
So we need to bring this to a close here. And so I want to ask you guys one simple question. Going back to 1787, 88, in the last analysis, were the Anti-Federalists right, Tim? In their concerns, did as history has played out, the Anti-Federalists were right?
I'll go yeah.
Because and why do you think they were right?
Well, I think, well, first of all, it's attractive to me that they're using history. I'm you guys know that I look askance at just sheer legal reasoning. To me, it doesn't make it really doesn't make sense. Pure legal reasoning. So I'm always just stuck with, well, okay, what's happened in history. So I think the reliance on the boogeyman and the you know, their experience with a parliamentary sovereignty. So I think the Anti-Federalists were right to raise that specter, and I think the growth of the federal government has borne that out.
Mike, Anti-Federalists in the end, in the debates, they were better prognosticators of what would happen.
Yeah, I agree.
Is that your sense?
Yeah, it is, and it's. In fact, I find I know we're tasked with talking about Article 1, Section 8, but it's the arguments about Article 2 where I think is even more persuasive. I mean, it's kind of to my colleagues who are congressional scholars and bemoan the fact that Congress, you know, we've been debating for the last hour all this power Congress has, and my congressional colleagues, friends would be like, You're debating about something that's not the real issue. The real issue is Article 2 in the executive branch. But the Anti-Federalists had that argument going for them as well. So yeah, I agree.
Chris?
Yes, I agree. They are right, and thankfully so, because I think that as we expanded as a nation, as we become more diverse, I think we've seen that sometimes that's been imperative, right? And I always like to, you guys know, I like to throw in the 14th Amendment as well. And the idea of Madison finally gets his veto, right? In the 14th Amendment, with the ability of the national government through the Supreme Court to strike down state law. And I think that is actually, for the most part, been a good thing. But then going back to what you just asked Mike, David, was, are we going to see a pushback now on the current makeup of the court I would say yes, and I'd say we've already seen it. We've already seen it in some recent rulings, so which also worries me.
Well, and I agree with that. And what I find interesting is what they're going to push back on is really some things that have happened other than maybe the Affordable Care Act. They could push back on, but really they're going to push back on some things that are much earlier in the 21st and late 20th century here. That it's amazing that Congress has this power, but they don't exercise it consistently, because in order to do so, I was having a conversation with a colleague today who, and they said, well, why don't they use it more? And I said, because you have to have, if you think about it, when we've seen great expansive powers, it's when Congress is controlled by a single party. Lyndon Johnson, FDR, the progressives. We see great expansive using the necessary and proper clause. Other than that, maybe during Eisenhower, we saw it, the consensus, but it wasn't controversial stuff necessarily. Infrastructure generally isn't controversial stuff there. And we haven't seen them use, Section 1, Clause 8, Section, 18 here recently.
I do have one final thought. It just, again, I'm way out on a limb here. But do they really need to, since they've essentially created an administrative state and agencies are exercising broad power? They don't even need to bother with anything in Article 1, Section 8, let alone necessary and proper clause, because they've created an agency to oversee that. So students might want to think about, broad powers, yeah, in Congress, but we're way past. That's water under the dam if we have an administrative state.
That is a great insight. Mike, Chris, any closing statements?
Well, I would agree with Tim, absolutely. And back to your point, if we had a pie chart, and which of course we know the framers did not intend 3 co-equal branches of government. They intended the legislature to dominate. But where we are now, and as Mike's point, is like that pie chart, the executive branch has a way larger piece of pie, right? Than because Congress is not using its power. And to Tim's point, it is an administrative state. But I would argue, if you go back and break down the necessary and proper clause into those 3 different sections, that administrative state is covered within that necessary and proper clause.
Yeah.
All right. Professor Williams is the rock star of the group. You get the closing statement here.
Well, I thought that how we ended right now was really good for our students, for the students watching, right? I think that the tendency with a question like this is to go super into the weeds and specific, and I think you need to do that. But I think you also need to think about sort of the broader sort of constitutional scheme, the broader balance of power, some of the things that Tim and Chris and David were just mentioning. I think that would be a really good way to address this question, to do that kind of 30,000-foot view before you get too much in the weeds.
Well, students and teachers, and those of you who are just generally curious, we've enjoyed ourselves, which means I don't really care if you did and if you learned anything, because we enjoy being around each other and having a conversation. Next session, we're going to be talking about the 14th Amendment and equality, and this is one of my favorite subjects, and culture. And political culture is something I'm extremely interested in. And actually, I've come across some supposed scholars who think culture has nothing to do with law and the Constitution. So it'll be an interesting conversation next time we meet. Until then, peace, love, yogurt tacos. Bye-bye. Bye-bonds.